in Asheville, and very, very, very down to earth, but yet very knowledgeable. And so he's going to be sharing with us on wills and estates and the planning. Then we have Mr. Evan Dixon over here. Actually, might as well say he's one of my kinfolk. So he is a licensed insurance agent, and he was going to come and share with us about insurance, the ins and outs of insurance, the different types of insurances and what that entails. And then I'll be bringing up the rear, talking about pre-need funeral planning and all that is involved with that. So we're going to go ahead and get right to it, and I'm going to turn it over to Mr. Webb.
So my name is Carter Webb. I'm an attorney at the Van Winkle Law Firm in Asheville. We have an office in Asheville, thank you, and an office in Hendersonville. So I've been practicing for 12, 13 years. I do estate planning, wills, and trusts. The way I do presentations, I've got a slideshow. You guys stop me with questions, because this is about what y'all want to learn. So I'm not here to lecture. So if you guys have any questions, if you want to pass those out, that's fine. Yeah. And so if you have any questions about anything, let me know. So I'm going to get started. There we go. So I was looking at this before, because when I do presentations, I kind of say what the percentage of the U.S. population has an estate plan. So what percentage of the U.S. citizens do you think have a will? Is it, I'll just throw numbers out there. 15%? 15? 13, 20? So 40%. So it's a little bit higher than you think, right? So 60% of the people, it's between 60 and 70% of the people don't have a will. And if you don't have a will, and a will is a document that you say where you want your things to go at your death, okay? If you don't have a will, the state of North Carolina has a will for you. It's a statute that says where your things go at your death, okay? So an estate plan is kind of a map that reflects what you want, how you want your things to go. Switch a little bit. But we also deal with incapacity, right? So if you become incapacitated, there's also a document that says who can handle your affairs if you become incapacitated. So you name what's called an agent. It used to be called an attorney in fact. So those are the types of estate plans that we're talking about. I think I went. Let's see where I am here. Make sure I am where I am. Sorry, hang on one sec. No, I think it's working, but I'm making sure I didn't go too far. No, we're good. We're good. So I think you go that way forward and that way backwards, right? So basically, you know, this misunderstanding is that only the wealthy only people with a lot of money need an estate plan. So without an estate plan, you can't control what happens to your property when you pass away, right? Like I said, the state of North Carolina, if you're a North Carolina resident, will decide, first of all, who your executor is. So the executor is the one who administers your estate after you've passed away, and who your beneficiaries are. An estate plan, and that's all the documents we're talking about, doesn't completely avoid, but it helps avoid any disputes that you may have with your family members, okay? And it protects beneficiaries from themselves and from others. I'll operate off this real quick. You especially need an estate plan if your spouse isn't comfortable with handling financial affairs, if you have minor children or disabled beneficiaries, if you own property in more than one state. So say you own property here and one at the beach, right? And if you have a second marriage, so you think of spouses where they have children from previous marriages, and you don't want the children of the first spouse to die, those children to be disinherited. So those are things you really want to factor into, take into consideration about doing an estate plan. Do you guys have the slides? Okay. So I'm on slide 1, 2, 3. I think they're switching it. Yeah. If you go to the next one. Yeah. There you go. Yeah. So the estate planning concepts, and then if you keep going through those parts of it, there's planning for death, wills and probate, tax basics, gifting, trusts, and we won't go over all of that because we're limited on time. So when we're talking about, if you go to the next slide, if we're talking about health planning for incapacity, so when I do an estate plan, I do a will for my clients, I do a financial power of attorney, and a health care power of attorney, and a living will. So when we plan for incapacity and dealing with health care, what you're doing when you do a health care power of attorney is you're naming an agent, so someone that you trust to make health care decisions for you if you can't make them, okay? So those are the documents that we're talking about. And then we do also a living will. So a living will is an advanced directive. So when we're talking about planning for incapacity when dealing with health care, if you don't have a power of attorney from a financial standpoint, then you become incapacitated, say you have dementia or you're in a car accident, then what's going to happen in order for someone to have the authority to handle your financial affairs in the state of North Carolina, you have to go and get a guardianship. So you have to get a guardian named for you to where a court appoints a guardian to serve. If you've got the documents in place, then you don't have to, well, you won't be going through that. Then your loved ones don't have to go through that. So you've named somebody to be in that part. If we can go to the next, yeah, good. Perfect. So planning for incapacity, the healthcare directives, we have the healthcare power of attorney, and we have a living will. And for me, those are two different documents that I use. The healthcare power of attorney, like we mentioned, allows for someone to make decisions for you if you can't make them from a healthcare standpoint. So say you're in the hospital and the doctor says you need surgery. You've named an agent who can make that decision and who has the authority to make those decisions for you. And then you have a living will also. So a living will, does anybody remember the Terry Schiavo case years ago in Florida when George Bush was the president and Jeb Bush was the governor of Florida? So a lot of the documents were designed because of that. Terry Schiavo's parents wanted to keep her alive. Her husband did not. So when you do a living will, you make decisions about when you want to continue to be hooked up to a life support system if that's the only thing that's keeping you alive. Okay, so that's a different document that we work on. And in those documents, we talk about the disposition of remains, funeral services, whether you want to be cremated, organ donation, those types of things. Good? Go ahead.
The healthcare power of attorney cannot dispute the living will, can they?
So I think the question is the healthcare power of attorney, which one? So you have two different documents, living will and a healthcare power of attorney.
Okay, say in your living will, you say you don't want no resuscitation.
Correct.
But the healthcare power of attorney felt like that you should.
So what I think what the question is when is the agent allowed to have the authority to override what you said in living will? Okay. In the statutory document, in other words, where the document is designed by statute, you as the person that's signing the living will put in there whether or not you want the healthcare agent to override what you've said. So you make the decision at the time whether you want the agent to have that discretion to override what you've said. So you make decisions like, I don't want to be hooked up to a life support system in these situations. And you make decisions about whether or not you want to receive hydration and nutrition artificially in those situations. And then you go forward and you say, if I have an available healthcare agent that's acting and gives instructions that differ from what I've said, then you have the option to say, I want that agent to be able to override it, or I don't want the agent to be override it. And the idea behind that is the agent is there at the time, can make decisions, but you want to be able to trust that agent. So people have different opinions on that. Yeah, good question. Okay. Yeah, thanks. So we talked about incapacity. So if you become incapacitated, so somebody yell at me if I'm going too far over, Cody. Okay. If you become incapacitated and you don't have a financial power of attorney, and it's called a durable power of attorney, then the only way somebody is going to legally have authority to handle your bank accounts, if it's just your bank account, is by getting a guardianship, and that's through the court. And it's time consuming and it's expensive to do. So it's good to have the financial power of attorney in place. Thank you. So we're talking about property management tools when you're incapacitated. Now when we're talking about bank accounts, if you have accounts with your spouse, those are jointly owned bank accounts. And if you become incapacitated, then your spouse, if your spouse is on that bank account, has as much access to that account as you do. So there's no concerns with that, because then the spouse who does have capacity can continue to deal with that bank account. And that's what we're talking about, joint owners. And we have the financial power of attorney, also called the durable power of attorney. If you become incapacitated, then that agent has the authority to handle those bank accounts, investment accounts, real estate, sign contracts for you, things like that. Okay. I won't go into the living trust, but you can do a trust as well. Okay. We talked about this at the very beginning. What happens if you die without an estate plan? When you have jointly owned property, the person who is the survivor, if there's two people on the account, whether it's a bank account, an investment account, or even real estate, the two people that are on the account or more, the survivor between all of them ends up getting that account. Okay, so that's the jointly owned property. If you have life insurance, when you fill out, when you sign up for life insurance, you name a beneficiary on a beneficiary designation form, and hopefully you name a secondary beneficiary in case that particular beneficiary dies before you do. Those don't go through probate, as long as you have the beneficiary designation forms in place and correct. And Evan will go over that, and that's important, extremely important. IRAs, 401ks pass the same way that life insurance policies do. You name a beneficiary of your 401k, your IRA, 403bs, those retirement accounts. Don't name your estate the beneficiary of any of those, okay? All other property generally passes according to the laws of intestacy. When I was in law school, I was 35 when I was in law school when I first started. And I had 2 children at the time, and my understanding, I didn't have a will. My understanding at the time was that if I died, everything went to my wife. And I took a wills and trust class, and this was in South Carolina, and it's similar in North Carolina. And I learned quickly that if I were to die without a will, anything that was solely in my name that didn't have a beneficiary designation, some of that would go to my minor children, and that's a problem, because you don't want minor children to inherit anything. It becomes a big issue. So that's the laws of intestacy. Yes, ma'am. Is the question, where do you keep your will?
Right, but see, what I'm saying is the oldest sibling probably knows about it, I know it. So he would tell my other siblings, my other children, but then they probably would get, how would you handle that? You know, they probably say, well,
So while,
this is all I know, this is all the kids would know, the first kid.
so while you're alive and you have a will in place, and as long as it's a valid will, you want to keep it in a safe place, and you want your loved ones to know where it is.
So I would tell, okay, maybe. Would you show it to him though? Because, maybe I wouldn't show the other 2 siblings. So I'm just telling the older
So when I answer the questions, it's a general answer. It all depends on the situation, right? So
Well, in Collier County, you can have it registered at the courthouse.
you can file a will with the clerk of court's office in the county in which you're in, right? What we do, we keep the original wills at our office for our clients, as long as they're good with doing that. the way it works after you've passed away is then that original will, the original signed will, has to be filed with the clerk's office, the clerk of court office in which you were a resident at the time of your death. Where you keep it while you're alive, I don't recommend filing at the court. You can. I don't, because then what if you change it? Then you've got to deal with all those issues. And again, it depends on the circumstances. But you do want that will to be kept in a safe place where people that you know and you love and you trust know where they are, where it is. Because that's the controlling document after you've passed away, as long as it's a valid will.
If you file it with the clerk of court, you had an addendum, or you changed the power of attorney, you just go up there to the clerk of court and submit a new will or an addendum.
So the question is, when you have, and there's two different, I'm going to give you two different answers because we're talking about two different documents. If you have a will filed at the clerk's office and you do an addendum, it's called a codicil. It's a fancy way to say an amendment to a will. Then I think you're correct, and you would want to file that codicil with the clerk's office. Power of attorney is different. It used to be the power of attorney, you had to file it with the Register of Deeds. It's no longer required to be filed with the Register of Deeds in the state of North Carolina, but some financial institutions still require it to be filed with the Register of Deeds. And the Register of Deeds is where you also have your deed for your property, okay? And it'll give you that stamp on the top. If you amend your power of attorney and you've already recorded it, then you have to record something else with the Register of Deeds, letting everyone know that you've changed your power of attorney. And that's why I don't record powers of attorney unless we have to. But you do have to record something that says that you've changed your power of attorney and that one's no longer valid. Okay? Good? Okay. Okay, I'll have a silly answer.
We have everything in my children's name. Two of my daughters died, and I got 3 daughters and 2 sons. And my 2 sons, one takes care of my banking line, and one takes care of my medicine. Do I put all my children on my bank? I just leave it like it is. Let them figure it out.
So I think the question is, when you have accounts, do you put your children on those accounts with you?
But all of them, just leave my 2 boys.
My concern with putting children on accounts of parents is then the children have as much access to that account as you do and as much right. So I often get questions about, should I put my children on my deed with me for my house? And if you put your child or children, any of them, whoever you put on there, they become owners of that too. And conceivably and legally, they could have a dispute with you, or they could drain the account. I'm not saying they would, but that's always my hesitation with putting a child or anybody else on as an owner of an account. And that's where the power of attorney comes in for you, as far as if you have a financial power of attorney, then you could name who you think is best to be your agent if you become incapacitated. So I would, go ahead, sorry.
90 years old now, and I'm about to die in it. I went to the already legal.
Well, you look good. So I wouldn't have guessed you were 90, so.
One of my boys is 54, and one see, I want to sit down. Beat them to the God will rest my daughter.
I don't know. Ask the question.
Put them all on my deed and on my house.
Well, again, they become as much of an owner as you are, depending on what you put them on there for.
They name me on the deed.
Mm-hmm. Yeah, if you put it on there with rights of survivorship, now you could give them a 1% interest and put it with rights of survivorship. Good? Okay. Yes, ma'am.
What you're offering in the legal aid through the senior citizen center, they offer free legal aid to help with wills and stuff. Is that, would you recommend that? Is it better to
Well, typically legal aid, so we have Pisgah Legal Services in Asheville, right? And Pisgah Legal Services is based on needs-based. So it helps people who can't afford to pay a lawyer. I think it just depends on the circumstances. And I'm assuming the legal aid does the same thing, to where they provide legal services to those who can't afford to pay a lawyer. And if that's the case, then they do good work. I mean, if it's a truly established, like a Pisgah Legal Services, which is again in Asheville, they do great work there. Yes, ma'am.
If you have a living will, and you have everything documented in your living will that you want to be done, do you still need to see an attorney to have it notarized? Or can that person that wrote out the living will, if she's the notary, can she notarize it for you?
Just to make sure we're talking about the same thing, you're talking about the living will, like the advance directive, when you don't want to be hooked up to a life support system, or are you talking about a will? A will. Well, a living will and a will, I don't know why they ever named it the same things, but a living will is a different document from a last will and testament. So when I think of last will and testament, I'm talking about who you name as your executor, who the beneficiaries of your estate are. Is that the document you're talking about?
Yeah.
Okay. So in order for a will to be valid in the state of North Carolina, you have to sign it in front of 2 witnesses and a notary. And the witnesses can't be family members and can't be beneficiaries of your estate. Yeah. You don't have to have a lawyer to do it, but you do want to get a notary, and a notary is not always a lawyer. Okay. Testacy laws, okay. So the question was earlier about filing with the clerk of court when you're alive. After you've passed away, that will is the controlling document, okay? Whoever has the original will after your death needs to present that will to the clerk of court of the resident of the county in which you're in. We're in Caldwell County? Okay, I know we crossed into Burke, sorry. So in Caldwell County, so the clerk acts as a probate judge. So when you think of a clerk of court, the clerk of court is the probate judge. And the clerk approves the will or doesn't approve the will, depending on if it has the right witnesses, if it's been notarized, and those types of things. So if the clerk approves the will, the executor gets appointed as the executor of the estate. And executor and personal representative are interchangeable. They mean the same thing, okay? And that's the person who's in charge of your estate. And you also name a guardian for minor children in your will as well, okay? That's what we're talking about. The clerk of court oversees everything. So anything that you have that's solely in your name has to be presented to the clerk of court. Not physically, not literally presented, but documents that you say, I have an account at First Citizens and a checking account and provide all the information. And all of that has to be moved to an estate account. And the executor is the person that legally owns the account for the benefit of the estate, okay? So the personal representative, also known as an executor, collects the assets, then runs a notice to creditors in the paper. You've probably seen those notices that run. And they run for 4 consecutive weeks in a local paper. And they allow any creditor to file a claim against the estate for a 90-day period of time. So what the executor is doing is waiting and seeing if anybody's filing claims. And if those are valid claims, then the executor decides when to pay them and has liability for not paying valid claims. And then, once those debts are paid and once that notice is run, the executor then makes the distributions based on what the will says. The misunderstanding with the executor is, and I've sat in a room with family members, and 6 siblings are sitting there with the sister who's named the executor. And everybody comes into the meeting thinking the sister is in the best position and she can do whatever she wants. And I sit with them and we talk about everything, and I said, she has the most thankless position because she has all the work and all the liability while everybody else waits and complains and says it's taking too long. So when you're an executor and you name a personal representative to handle your affairs, you make sure that you have somebody that you trust and that you know can actually do the work, because it's a thankless task. So when we talk about probate, we talk about pros and cons. The pros are that the costs of probate are typically modest, unless you have a large estate. The court, while it's a good and bad, the clerk oversees everything. So that's, in a way, a good thing, because you've got somebody who's making sure that the executor is doing what he or she's supposed to. Protection against creditors. We talked about running the notice to creditors in the paper. The cons, it can be time-consuming for large estates, but sometimes it's better to do it that way for other estates. Could be title transfer delays. The fees, fees are modest, but so there's a fee that the court charges 0.4% of the value of the assets that go through probate, and there's a $6,000 maximum. So for those that have a large investment account, we don't want that to go through probate, because then you pay a $6,000 fee on it if it reaches that amount. Okay. Ancillary probate, for those that have real estate in another state, if you have, say you have a house at the beach at Myrtle Beach and you have here, and you pass away, and that house is just in your name, there's going to have to be a secondary probate in Horry County where Myrtle Beach is. So you have a probate here, and you have an ancillary probate in South Carolina, and that's unnecessary. There are ways to avoid that. And everything that you do in an estate is a public record. You could walk in the Caldwell County Clerk of Court's office right now and pull any estate file and see exactly what's in that estate and who the beneficiaries are. So it's all public record. Okay. You can avoid probate by a number of ways. Own property jointly. So we talked about joint with rights of survivorship. If you have a car, look on the title of the car, and you're married. So if you own a car and you're married, look on the title of the car and see how it's titled. If it's in both names but it doesn't have the acronym for joint with rights of survivorship, which is JTROS, then that means that the husband owns 50% and the wife owns 50%. And one passes away, then they have to go through probate in order to get full title to that car. Okay? Same with bank accounts and investment accounts and real estate. Always, always look at your beneficiary designation forms. I can't stress that enough, whether it's life insurance, 401ks, IRAs. Those are huge to make sure that we don't have to have it payable to the estate. I've had people that have had annuities, and for whatever reason, they've named their estate as the beneficiary, and that is so unnecessary to have it go through the estate. It takes more time, it costs more, and it's just unnecessary.
At 401, I had, they always give us a form every year to update the beneficiary to your 401. And they said that if I put my wife down 100%, I wouldn't have to get it notary. But if I wanted to give, like my children, 15 or 20%, she'd have to sign that she agreed and get it notary.
Did everybody hear that? So he's talking about a 401k. So 401k have their own retirement rules. And the default is that the spouse is the beneficiary of the 401k. But in order for you to name someone besides the spouse as a beneficiary, the spouse has to sign something agreeing to do that.
You think they won't give up their money?
No, I think it's... Maybe not. Maybe not. I think it's a public policy not to make sure that you're not skipping on paying.
Cheating your wife.
Yeah, I don't know about cheating part, but it's the
Taking her for and giving somebody else for their
correct.
vacation.
Yeah. They have rules. The retirement they have rules about that. But 401k is where you definitely want to make sure that you name the right
They
beneficiary.
do it every year.
Yeah. Do they?
Yeah.
So you have to change it every year?
To make sure.
Oh.
I mean, you don't. They give you a form every year just in case somebody do want to change it. Somebody's wife maybe has died,
Right.
but I've signed different ones every year.
Right. I was checking on time. Sorry. I'm listening to you. I promise. I'm making sure I'm not going over.
I was thinking that I had to get it notarized,
It-
and then the 100%, if I wanted to give somebody 10 or 20, she'd have to agree.
But you do want to make sure you have a secondary
I got my
beneficiary.
daughter down for that.
Okay. Okay.
Yeah.
Yes. So you definitely want to have a secondary because
Yeah.
typically for those 401ks, IRAs, they have a default in the contract, and if you don't have a secondary beneficiary and your wife dies before you do, heaven forbid, then typically that'll go to the estate, and you just don't want it to go to the estate. It's just unnecessary. Okay. Good. Next one. And trusts are a way to avoid probate also. Okay. Revocable trusts are a way to avoid probate, so you can create a trust where you name a trustee to be in charge of your assets, and you title things into the trust. So it's a revocable living trust, and you don't lose control over the things that are in the trust. It's just another way to avoid the probate process. And I think am I getting close on time? Yeah. All right. So I'm going to keep going, skipping through. Anybody have any questions about the probate process? So the cornerstone, and I'm going to drop off from the slides real quick. Basically, the cornerstone of the estate planning documents: a last will and testament, and we went over that pretty extensively. A financial power of attorney, a health care power of attorney, and a living will. And those are the documents that are the defaults for me when I prepare estate plans. And so what you're doing is you're naming people that you trust to be able to manage your financial affairs if you become incapacitated and after your death, and your health care if you can't make those decisions for you. And the big thing that I always take away from this about doing that is that you're in control of making those decisions when you've created these documents. And what it does is it gives you peace of mind personally to know that you've got this in place and you've got someone who's going to do the work that you want them to do for you. And then your legacy, the things that you built for yourself during your lifetime, are going to go to the people that you want them to go to. Okay. That's all I have. And we also deal with how you want your funeral arrangements, and that's in the living will. And that's huge also, because you can fill out your final wishes about how you want your memorial ceremony or your celebration of life to be. And I've met with clients all the time after mom's passed away or dad's passed away, and they are so thankful when someone has filled those forms out because they knew that that's what mom or dad wanted to be done. So, go ahead. Oh, sorry.
What was the acronym for when two people jointly own something?
So think of it joint with rights of survivorship. So you think of it this way: it's jointly owned with rights of survivorship. And what that means is whoever the survivor is takes. So it's JTROS.
Okay, because my ex-fiance and I have a car that's in both of our names, but if something should happen to him, I was trying to figure out, would I be able to keep the car?
So if it has
He got it for me.
if it has the JTROS on it and he dies, then it passes to you automatically. But if it doesn't, then that means he owns 50%, and his estate then owns 50%. And you got a problem. So if the intention is for whoever the two of you is to survive to take the car, then you want to change that. And that's done at the Department of Motor Vehicles, the DMV.
Something was brought up when my mom passed. If you pass and your children are married, does what you leave to them automatically is for them and their spouse's will?
So the question is, so you have how many children? So 2 children, and you tell me if my question is not right. She has 2 children, and she says if she leaves her estate to her 2 children, does her 2 children's spouses also take? Right? Is that the question? They will not. So if one of your child dies before you, heaven forbid, you name where it goes at your child's death. And my default typically is if your daughter, you have a son and a daughter?
Well, it was my mom passed,
Oh, okay, so you're talking about you, okay.
Build her house to my nephew, her grandson.
Okay.
And when he brought papers, said, you know, that we had to sign off, because it was real to him, that his lawyer said we had to sign that we didn't want any more, you know, contact, or we can't take any control of it. It was all in his name. And then, my daughter was real the car.
Okay.
You know, and so in all of that, because he is in the family now, my son-in-law, he had to sign, was supposed to sign the paper too, that we didn't, you know, we didn't take any legal action.
And that was just for the real estate, right? Yeah, because there's certain rights that spouses have to real estate. So what real estate attorneys will do, even though the son-in-law doesn't have any interest in that, they'll have the son-in-law sign the deed transferring it. Or it's just, it's so there are certain spousal rights when it comes to real estate. Does that make sense? Somewhat? But I think the overall question is, if you leave assets to your children, do the spouses benefit? And the answer is no, they benefit indirectly by receiving the money. But if your child dies before you, then you name who would be the successor. And typically it's your grandchildren. But that, I'm not sure that's what you're asking.
Well, I just wanted to make sure, you know, that, like, for instance, if both of us passed and everything had went to our children, you know, even though we left it to our children, the in-laws couldn't fight.
So are both kids married? Okay. So both of you pass away and you left it to both of your children equally, 50%. And then it becomes their own asset. So that once they commingle that with their own funds with their spouse, then it becomes a marital asset. So the spouse, the in-law, the son-in-law or the daughter-in-law will benefit indirectly, but they're not a beneficiary of your estate.
I think what she's talking about is, in the same way as when you purchase property together.
Right.
At the time of divorce, you can fight for those items. The property that was passed down to that son or daughter, would that in-law, would they at that point be able to fight for it, in a sense? Like, would they have rights to that property? Or would that property stay within the family? But I think that because it's marital, as soon as it drops inside that marriage, it goes like that.
Yeah, and so I think the big issue is if you leave assets to your children who are married and those children then get divorced, is it considered a marital asset, right? There are certain provisions in the division of the marital assets about whether inheritance is considered a marital asset or not, and that will be determined through the divorce. But more than likely, it's not as protected as it could be. So if you left assets to your children who have divorce issues or potential or marital issues, then you want to talk with an attorney about how that can be protected and stay in the family. Especially when it comes to land. I mean, land is a huge thing that's been in families for generations. And you don't want somebody to come in and take it because they were married to your child and then they divorce and then they become an owner of the property, and that wasn't the intention. Yeah. And those are the types of things that I would strongly recommend you meeting with an attorney to work through. You can put it into a trust for your children that are protected from their creditors, from divorce, and from bankruptcy. Yeah. I think I'm out of time. Okay.
If you have, land, and you left it to your children, and one child pays all of the taxes.
I agree. That's a big uh-oh right there. That was perfect timing.
Does that give them the right to own that land?
The one that's paying the taxes? So let's say 3 children inherited land from you, right? Say they inherited 100 acres of land and you left it all to all 3 of them. So each of them in that situation would own a 1/3 undivided interest, meaning that they don't own like this spot and this one owns this spot. They all own the 100 acres, one third, one third, one third. They're all equally responsible for the taxes. They're all equally responsible for the upkeep of the property. They're also each allowed to access and use the property equally among the three of them. If you have one owner that's paying the taxes on it, just because that owner is paying the taxes on it doesn't mean that that owner has more rights than the others. But that one that's paying the taxes can then go over the other, go to the other three to try to collect the other 2/3 share. That's where it gets really complicated, and that's where, I mean,
Okay, so say the one that was paying the taxes died.
and it gets even more complicated. Then you're going like, then you got to learn fractions all over again. Yeah. So then that 1/3 goes down to whoever the beneficiary of that person's estate is, and then say they have,
Still 1/3.
that's still at 1/3, not the rest of it.
And could they ask the other 2/3 to pay them
Their share of it, absolutely.
what their parents paid
Mhm.
for,
The solution is to do a partition sale where you go to a judge and get the judge to divide up the land if it gets to that point. You have a judge and you go a partition and you have the judge divide up the land. If they can't come to terms and it's getting to be too much financial burden on the person that's paying the taxes, and the other owners aren't paying it. Yeah. All good? Thank y'all for listening to me. I appreciate it. And I normally stick around, but I've got to run. I hate leaving. Cody and I talked about this. So I'm going to leave some business cards with Cody. If you guys have any questions or concerns, feel free to contact me. They're on the slides as well. So thank y'all.
Good meeting you. I'll talk to you later.
permanent life insurance like whole life and universal that is a little bit more expensive than your term policy. So you got two benefits. One thing is that you have it for the rest of your life and you're locked into your monthly fee. Another thing that it builds up a high yield savings account for you that you can borrow from. Maybe you want to do some real estate or something like that. Maybe you need to buy a car. And then you pay yourself back without having to pay interest if you were to get a loan from a bank. Tough thing is that it's a little bit more expensive than term. We'll get into term life. Term life is awesome because you get a lot more money or a death benefit for a smaller amount that you pay per month. The tough thing is that it's 10, 20, 30, maybe 40 years, and then you got to get qualified for insurance again. One of the things that they look at when you're applying for life insurance is how old are you. So the older you get, the more it costs. So a 30-year term, they might say, I can give you $300,000 for 30 years, or you got to pay it $60 a month. But after that 30 years is up, you're not insured anymore. They do have some terms that are guaranteed to get you into a permanent policy after that 30 years is up. But again, that monthly payment is going to change. And the awesome thing about term now that I'm seeing in North Carolina is they have a return of premium. So you pay 30 years every month, you get all that money right back after your 30 years is up. That's pretty good. You know, you got a lump sum coming back to you that you can do something with. So term is cheaper. You get a bigger, and when I say, my wife said, don't say cheap. When I say cheap, I don't mean quality. I mean how much you pay. Okay? He said I should say, cheap. Less expensive. Okay, you say that's too much. Less expensive, right? That sounds better though. So she'll fuss at me if she sees that I said cheap. So that's permanent life insurance. We have term life insurance, and then we have final expense. Final expense aims toward the age of 45 to 80, and sometimes even 85. This is when you say, I want to be able to pay for my funeral. I want to be able to pay for some final things that I want to get in order, and I might want to leave some money to, $5,000 here or there to a kid or something like that. That's final expense life insurance. It is actually whole life, but since you're not getting a huge amount, you don't get more than $50,000. They gave it another name and called it final expense. I'm quick. I'm quick. Is there any questions?
I'm going to ask you on the whole life insurance.
Yes.
You said that it's going to be paying premium on this insurance. You locked in.
Yeah, so
Now, are you locked into a certain age?
So when you're 120, they just go ahead and give you money. But other than that, you got it.
Okay. Not all insurance companies like that whole life insurance company.
Well, whole life is a type, so all insurance companies that sell whole life, they will be like that. Now, make sure you work with your agent, because there are some where it may go up or it may change, or they may tell you that you got a whole life and you really got a term.
Okay, on the whole life. At a certain age, does it may go up?
No, if I was to get my daughter at 15, a whole life insurance policy, it's going to stay the same $10 a month until she goes at 120.
Have you ever heard of a whole life insurance telling a person that after, let's say, 65, the premium will not change. Any change because of this age right here, 65. As long as you have it, it's like instead of it increasing on the cash value, you are more like not paying to what the cash value is going to increase. It's like I'll say like you paying
Very minimum,
just to keep it paying the minimum just to keep it, but your cash value is not increasing.
Right.
It says whatever it is at that point. So you're just paying, or you can cash that insurance policy in, whatever your cash value is, that's what you will get from.
Yeah, you can cash in the surrender charge, but they do have it where you can just pay a minimum. So this is just keeps you, so you got your death benefit. You still get your death benefit, but if you don't pay, a certain amount, which when I have a client, this is the amount to pay. you want that cash value. Now, if you come into where I call you, because I call people, and they say, well, I can't pay this one, I say, okay, well, you can just pay this amount and we'll keep it going. Is that what you?
But what I'm saying is, what I'm asking is, like you said, you continue to pay your premium, but at that age of 65, they will tell you that you continue to pay this one, you continue to pay this 165. Your cash value don't increase. You're just paying just to keep the insurance.
Yeah.
My dad is like that. He's had it ever since he was like.
That's not like a universal. I think it is like a universal, but I think it depends on who sets it up. Like when I set up index universal life account, I could set it up where I get a lot of money. Or I can set it up where you make a lot of money. I set it up where you make a lot of money. But it depends on the agent that sets it up. And that's one thing that I'm an insurance broker. I'm not an agent. An agent works for one company. So when they say I got the best account for you, it's the best account that their company will allow you to do. As a broker, I deal with over 100 different carriers. So when I'm working with somebody, whenever we put the information in, I see all the different options. So we go through it and make sure that it works for them. But a lot of it falls on the agent, and you gotta make sure you can trust them. And they know what you're talking about. And ask for illustration. What's that?
I said, don't deal with family members that sell insurance.
And ask for illustration. They should show you everything and work it all the way out. You can ask for illustration. When you're doing, I would say always ask for illustration. It even show you how much you should make every year. You know? But yeah, it shouldn't just because you're 65. I mean, that's when you need it.
Well, you will still have the insurance, cash back, and you continue to pay your premium. But the cash value never changes. Yeah, you're not paying, you know, you sign up for the insurance. And you have it for 20, 30 years. And like I said, at a certain age, let's say, well, you can continue to pay, I'll say $150. You continue to pay $150 up until 65. After 65, they come back and say, well, in order for you to continue to have the cash value, in your cash, for your cash value to increase, we're going to have to increase your premium. And it go from $150 to $300.
I would, if you have something like that, I would love to see it. You can see how they set you up. Does it sound like something that had to happen?
Well, yeah.
It sounds like something that was set up. And it's so important to get life insurance that you trust who sets it up, because that means that's what it means. Yeah, because I've never set up.
They make more money than very,
It sounds like the agent.
They put a cap
We're
on
on
it.
vacation.
Yeah, they capped it out, and then they dealt with it to make a profit. But now, you have the option of cash it out.
Right, but still, then you would have life insurance. So I don't,
Yeah.
I don't. Yeah, you do a 1035 exchange, but you good pay on it. You want to keep that. So I'll give you a card, and I'll give everybody a card, but I'd love to speak to you if we can go a little deeper. Okay.
What was the name of that term insurance you said? They pay it for so long and then they'll give you the money.
ROP, return of premium. Return of premium. And a good thing, I was gonna say a good thing about like term or good reason to get term life. Suppose you buy a house for $300,000, you get a term life insurance for $300,000. So if something happens to you, your family can stay at home. A lot of people say, well, I got broken insurance, but that's a limit. So if you have a house for $300,000 and you die in 15 years, now you only owe $150,000. They're not giving your family that check. That goes to the limit. But they change how much you pay. You're paying the same every month like you pay when you had $300,000, but you don't get that money. So I think you should do a term. But then your family might say, hey, you ready to go, we want to move. Let's sell this house and now we got some money in our pocket. So I mean, it's they They make it sound good, but that term life is yours. That you own that check goes to your family. Where with the mortgage insurance, that's for the money. That's not necessarily for the body.
Is, accidental death insurance, is that necessary? I mean, is it,
Yeah, but a lot of times with life insurance, you can get that in a rider. So you get the accidental death, you can get long-term care. If you were to get disabled, that's a rider that comes so that you don't need to have $2,000 of life insurance and you're struggling because you can't work. You can take that and start using it for your medical bills and things like that. So you got to get a rider, and that's something that your agent will be able to help you with.
there are life banks that offer long-term.
Well, banks probably have insurance agents that work there. You have to get, when I worked with Edward Jones, I got my life and health insurance, that's part of it. So they're probably insurance agents.
Can I piggyback off of something? This is not in my presentation, but I wanted to interject this for you. What he just said is when you do have life insurance or if you don't, it is important that you do have an accidental death benefit rider on there simply because if you pass away from an accident and you bring a life insurance policy to the funeral home, pay for your funeral expenses. If you die from the result of an accident and your death certificate says accident, because it will check the manner, the doctor will check the manner of death on the death certificate. If it reads accident, the insurance company will not pay the claim. The insurance company will not pay the claim to the funeral home, pay for your funeral. If you did not have an accidental death benefit, like regular insurance without a rider for accident will not cover a funeral expense if you die from an accident. I just wanted to make sure I threw that in.
Any other questions? All right, thank you, guys. Yes, ma'am. Myself up there, so.
When you get it, just go straight to page.
Everybody hear me? All right. When you get your packet, go straight to page 2. And we'll jump right to it. So if you can go ahead and get... Okay, so I'm going to go ahead and start. So what we'll be discussing in this segment, we'll be discussing pre-need funeral planning. So it takes some elements from what Mr. Webb discussed, and it takes some elements from what Mr. Dixon just discussed, and we're going to put it in context of funeral planning, which is important. And I will say that I'm looking around the room, and there have been some that have already come and done their pre-funeral planning. So thank you for doing so. We greatly appreciate that. And so I want to give you a scenario. Now, disclaimer. Now, these are real life scenarios. I've used very general terms, so nobody will think, well, he talking about so-and-so. You don't know who I'm talking about in this. So I use some very generic names, but these are real situations. Excuse me. So, can you hit that again? So Mr. Smith develops a sudden illness and passes away. She leaves behind 10 children, each who are responsible for making funeral arrangements. 8 of the 10 children come to the funeral home and spend over 4 hours coming to a consensus on what Mrs. Smith's final plan should be. Could this have been avoided? Yes. Next slide. Mr. Jones has a father in hospice care. His intentions was to prearrange his father's services, but assumed he could not afford it. So he decided not to do so. Mr. Jones's father passes away 4 months earlier than anticipated, and no final wishes were in place. Could this have been avoided? So I'm going to go to the top 8 myths of pre-planning a funeral. Myth number 1. It's too hard to talk about. I hear this all the time. It's too hard to talk about. I don't want to talk about it. It's too morbid. But we know this is a very real fact of life. You know, when we're born, there is an appointed date. Okay. Myth number 2. There's no use talking about death when it's so far in the future. 2020 showed us otherwise. Am I right? Okay. Next thing. My loved one doesn't need to pre-plan his or her funeral because they're financially secure. This may be true, and I have had situations where a family, you know, they had the funds and the financing to pay for funeral expenses, but again, like the first scenario, you got 10 children, and all 10 children have an opinion, and all 10 children are sitting in my conference room with their own opinions. And then 1 hour goes by, 2 hours go by, 3 hours go by. I sat with a family for 6 hours before because they could not come to a consensus on what mama wanted or what daddy wanted. Next thing. The family already knows if he or she prefers burial or cremation. That's good. You know, I hear people tell me all the time, you know, well, Bro Cody, I want to be cremated when it's my time to go. Okay, well, you need to come put that down in writing. Because it does no good if our family just has a knowledge of it, but nothing's put in place. Okay? Next thing. They'll be gone, so it doesn't matter. That's very selfish. Because our families, if we love our families the way that we say we do, then we don't want them to have to deliberate. It's already hard enough when you lose a loved one. I believe everyone in here has lost a loved one. We know how hard that is, so it's even worse when you have to deliberate over certain things that are required at the funeral home. Next thing. He or she already has cemetery property. That's good. That's only one part of the puzzle. I hear people tell me all the time, well, I have a plot. Yeah, that's good, but you need some funeral arrangements as well. Because I've had people come in, and I've had situations like this, where people come in and say, well, you know, mama had a plot, but we ain't got no money. Mama just has a plot sitting out there, but the family has no money. And a lot of people don't realize that even with the plot, whenever the plot was purchased, if what we call opening and closing was not included in the purchase of the plot, meaning the digging of the grave, that's an extra fee that's added on at the time of death. A lot of people don't know that. Next thing. It doesn't make sense to plan now when he or she doesn't know where they'll be living in the future. Because I have people all the time that say, well, if I do a pre-need with you and I move to somewhere else or I move to another state, it can be transferred. Pre-needs are transferable. They are transferable. I'll even throw this in here. If you have an existing pre-need with XYZ Funeral Home, and at the time of death, the family says, well, I really want to use ABC Funeral Home, it can be transferred even at the time of death. Last thing. Perhaps the most popular, I can't afford it. I say that because in funeral service, one thing I tell all of my families, whether it's pre-need or even at need, you tell me what you want to pay. You tell me where you want to stay, and we'll make it work for you. So to say I can't afford it, that's an assumption. But we want to make things to be, we want to customize and make things be able to work for you. So, definition of a prearranged or pre-planned funeral. So there is a difference. A prearranged or pre-planned funeral is one in which details such as the order of service, merchandise, and the mode of final disposition is documented, meaning whether you want to be buried or cremated. So, a pre-need, definition of a pre-need. According to the North Carolina Funeral Service and Cremation Laws, a pre-need funeral contract means any contract or agreement or mutual understanding or any series of combinations of contracts, agreements, of mutual understanding, whether funded by trust or prearrangement insurance. So a pre-need means you come in, you sit down with your funeral director, you pick out the merchandise that you want, the casket, the vault, any other additional merchandise that you want, and a funding mechanism is put in place, meaning whether you're using insurance or whether you're using a trust account. The most common way to do it now is through insurance. So what most people do whenever they do a pre-need, I know for what I have done, most of the time when people come in, they do a pre-need, they say, well, Mr. McCain, I have existing insurance. What you can do with your insurance, you can call your life insurance company, have them send over what's called a collateral assignment form. What that does is when you sign it and your funeral director signs it and we submit it to your life insurance company, that's stating that at the time of your death, the funeral home is going to send your insurance their bill. They're going to pay the funeral home what they're billed, and the remaining amount will go to your beneficiary. That's called a collateral assignment. That can be done on a pre-need, and it can be done at need as well. That's most commonly how people pay for funeral expenses. Or some people come in and choose to get a final expense policy, which at that time, your funeral director, if they're licensed to do so, can write you. Okay, next slide. So specific Federal Trade Commission rules, I have to make sure I go over this. It is important that you know your rights as a consumer. So the Federal Trade Commission rule of 1984, it requires us to follow certain things. So it governs how we as funeral service practitioners represent our pricing, goods, and services to the consumer. So as a funeral director, and I'm going to go to that next slide. I'm going to go over some specifics. So as a funeral director, whether you sit down with me or whether you sit down with any licensed funeral director, this is what you should receive. Number one, whether you're doing a pre-need or whether it's at need when someone passes away, you must be given a general price list. A general price list from the funeral home outlines all of our services and the charges. If you're not given a general price list, you have the right to ask for one. You have the right to ask for one. A funeral home cannot deny you a general price list. You can call any funeral home around and say, hey, could you mail me or email me a general price list? I'm doing some shopping. I want to know what you have. And by law, we have to send you one. If a funeral home tells you, no, we can't do that, then we have a problem. Okay? Number two, you must be given an itemized statement of goods and services when doing a pre-need or at need. We have and also it's called the funeral bill. So on your funeral bill that you get pre-need or at need, it itemizes everything that you picked out, all the services and the merchandise and the cost, and it gives you a total. And there's certain disclosures on there. You can't go to a funeral home and the funeral director say, okay, everything gonna be $59.95. And you don't see no itemized statement that the funeral director has to sign and that you have to sign and that you keep a copy and the funeral home keeps a copy. If you don't receive that, we have a problem. And I'm telling you these things because stuff like this happens. Okay. Number three, I'm just going to throw this in there because a lot of people don't know. When it comes to embalming, and I say this, on a pre-need basis and at need basis. When it comes to embalming, now embalming is not required by law. Okay, let me throw that out there. Embalming is only recommended if you're having certain types of services where you're having a public viewing for any extended period of time. But there is no law that requires embalming unless you are being shipped to another locale on a common carrier, most commonly an aircraft. That's the only time embalming is required. But with embalming, when you come in to do your pre-need arrangements, we already have in place what's called an authorization form that you can sign yourself to say when you pass, you already have authorized that funeral home to do embalming on your body. At need, you are required to give authorization for embalming. A funeral home can't just come pick up the body and go take it and embalm it and never ask you for permission to do so. And then you always should sign an authorization stating that you gave permission to do so. That is an absolute requirement. So if there's ever a situation where And I have known situations where people have told me, you know, well, the funeral home came and picked up my mom and they went ahead and embalmed her. I said, well, did they ask for your permission? No. Well, we got a problem. Okay? Next thing. You must be shown a casket or out of burial container price list when discussing these items. So when you come in to do a pre-need, there are two other price lists that you must be shown. This is pre-need and at need. One is called a casket price list. It shows you the listing of all the caskets that that funeral home offers and their prices. Out of burial container, when I say out of burial container, either the vault or the grave liner, it lists all the ones that that funeral home offers and their prices. So you must be shown that as well when you're doing arrangements, pre-need and at need. Okay? Next thing, number 5. You must be shown the necessary disclosure for out of burial containers. What I mean by that, and this is another common misconception. When I say out of burial containers, I either mean a grave liner. Grave liner means that's the container that the casket goes in at the cemetery that's non-sealed, or a vault, which it serves the same purpose except it does seal airtight. That's the difference between a liner and a vault. But whenever you're discussing these items, you must be shown the disclosure that an out-of-burial container is not required by law unless the cemetery requires it. So some cemeteries require a minimum type of out-of-burial container, some cemeteries don't. So if a cemetery does not, and a funeral home tries to con you into buying one and you tell them no, the cemetery doesn't require it, but they tell you that it does, then we have a problem, because stuff like that has happened. So you must be shown that disclosure. And number 6, and I have to harp on this a little bit. I'm going to point this out. Only, somebody say only, a licensed funeral practitioner or a registered apprentice operating under the license of a funeral practitioner has the authority to discuss prices of goods and services. So Joe Blow that works for XYZ Funeral Home that's not licensed nor an apprentice cannot come to you and say, oh, well, we can do it for $39.95. That's a no-no. Nobody that does not hold a valid funeral director's license or is a registered apprentice under a valid funeral director's license has any business discussing prices of goods and services with you. They should not do that. That is a problem, because I know folks that do that. And that is a problem. Go to the next slide. How can you know if you're talking to a licensed funeral director or registered apprentice? I'm glad you asked. If you go to this website right here, the North Carolina Board of Funeral Service, ncbfs.org, and you click on that consumer tab for consumers, at the very top it says look up verify license. You can look up and see who's licensed in the state of North Carolina. Also on there you can look up and see who is a registered apprentice in the state of North Carolina. So if the person that you're talking to don't come up on that website, you don't need to be talking to them. Somebody say amen. I feel like I'm preaching now, because we got to get some stuff straight in the hood here. Go on a little bit further. So that's that screen there. You can say select license type, whether they're a funeral director, funeral service licensee, meaning funeral director and embalmer, or registered apprentice. It's on there. So you can type in their name, and if it pops up, you're good. If it don't pop up, we got a problem. Go to the next screen. So I'm just going to hear shit now, since I'm talking about that. There go my stuff right there. Now I'm licensed. All right, now I'm licensed. There go my, and this is the other thing. So up at the top left, that's my funeral service license, 3428. Also, you see my funeral home establishment license and my funeral home pre-need establishment license. I need to harp on that a little bit. Any entity that you go to that says that they sell pre-needs or they do pre-arrangements, if they do not have a pre-need establishment number, they cannot legally activate your pre-need. They cannot legally take your money. They cannot legally have an insurance policy assigned to their firm if they do not have an active, you see it says active up there because it'll tell you whether it's active or expired. If you do not have an active pre-need establishment license, you cannot do business as far as a pre-need basis with that establishment. Same with at-need. If they ain't got no active at-need establishment license, they cannot perform services. They cannot do anything. Do I make myself clear? Okay, we good on that. If any time you have questions, please stop me. So we're going to go on with a little bit further. I just wanted to explain that so you know who you need to be dealing with. Next thing, how pre-need funeral arrangements are commonly funded. We talked about insurance. Mr. Dixon discussed that. Whole life, term life, burial, final expense, so insurance policy. Next thing, a trust account. Those aren't really done as much anymore because really with trust accounts, they don't build the growth like a pre-need funeral policy would. So we still have remnants of trust accounts that people had from way back in the day, you know, that of course we'll still honor, but it hadn't grown much because I had a client back in 2020, actually, at the funeral home that I do work for in Asheville. There was a gentleman that died who had a pre-need trust account that was established in 1987, the same year I was born. 30-some years. Do you know how much it grew? $150. $150. 30-some years, and that's all it grew with a trust account. That's why I don't fool with trust accounts. I do pre-need insurance policies that the rate of growth is higher, so that way at the time of your death, you know, cost of goods and stuff goes up, but it will cover you so that way your family doesn't have to pay out of pocket for anything. Okay? Next thing, single premium insurance payment for insurance policy. So that takes the place of a trust account. So if you come in and say, well, bro, Cody, I have $6,000 I want to put towards my funeral. I take those monies, we convert it into what's called a pre-need burial plan or final expense plan that grows, that accumulates growth, which will cover your funeral expenses. Okay, next thing. So I'm going to discuss the types of contracts. So we have two types of pre-need contracts. You have standard and inflation proof. So with a standard contract is what it is. You pick out everything, you know it's funded, and that's what it is. Now inflation proof is a little bit different. Now inflation proof, you can go to that slide. Now inflation proof contract does the same thing as a standard, and you choose, or you know, normally I recommend that type of contract, you know, depending on the situation. An inflation proof contract, what that does, say for instance, you come in, you pick out everything, and your total funeral bill came up to $7,000, and you had a $10,000 life insurance policy to fund it. Okay, so 20 years go by, you pass away, and the total amount of everything came up to be $11,000, and your insurance was only for $10,000. Well, the funeral home can't come and say, hey, we need that other $1,000. That's what inflation proof does. It keeps you from having to pay out of pocket for anything that's left over. Okay? Goods and services. So this is the statement that you're supposed to see whenever you come in to do pre-need funeral arrangements. That's that itemized document that you see pre-need and at need. So you are required to have that. So revocable versus irrevocable. So revocable contract, pretty much, it can be changed or revoked at any time. That's a revocable contract. Irrevocable, you can't. I normally let clients make that decision. You know, if they're confident, this is what I want, I don't want it changed, I don't want nobody to change it, irrevocable. If they say, well, you know, I might change some things in the future or we might do something else, then that's revocable. Okay? So, next thing. So when you're converting a pre-need contract to at-need, so you did a pre-need contract on mama 20 years ago, mama passes away, now it's time to do at-need. So number one, you have your consultation with your funeral director. Number two, you're given an at-need statement of goods and services. Again, you are required to have a statement of goods and services where everything is itemized. Number three, the funds are dispersed to your funeral provider. And number four, now watch this. Anything that is in excess over $1,000 and up has to go to the clerk of court when it comes to pre-need. The funeral home cannot give that to you if it's $1,000 and up. $9.99 on down, funeral home can write you a check for any overages. $1,000 and up, we're required by state statute to make sure that goes to the clerk of court because it has to go to that person's estate for pre-need, that is. Okay? Pre-need recovery fund. Now this functions similar to how the FDIC covers bank accounts. So somebody may ask, well, you know, if I take a pre-need out at so-and-so funeral home and that funeral home goes out of business, what happens? Your money's still covered. The North Carolina Board of Funeral Service has what's called a pre-need recovery fund. That's why anytime you do a pre-need, we're required to collect a $20 filing fee because the board takes that filing fee and puts into the pre-need recovery fund, which reimburses you for any damages suffered for a funeral establishment that went insolvent or went out of business. So your monies are covered. Normally what happens if a pre-need establishment goes out of business or something unfortunate happens, the state board will come in, take those pre-need files to another funeral establishment. And that establishment is required to send you out a notice, you know, we have your file, and then you have the option of either, you know, deciding to keep it with that firm or switch it to the firm of your choice. So I always like to clarify, a lot of people think, you know, if they have a pre-need at one funeral home that they're just locked in there. That's a myth, and if anybody tells you that, they're telling you a lie, especially if they're not licensed. Okay? You can transfer it at any time, before or after death. All right. Now I'll take any questions. Anybody have any questions about what we just covered when it comes to pre-need funeral planning or funerals in general when it comes to that? I saw this hand first.
Yes, if you are in an accident out of state, say you're in Georgia and you're in Florida and you die, do you have a limitation on how far you will come to pick up a body?
No. Actually, and we run into this quite often, more often than you probably realize, if someone passed away out of state or something like that, what we'll normally do is coordinate with a firm in the area where the person passed away for them to at least do the removal. If they're, you know, within driving distance, we'll many times go and drive and do the removal ourselves. If they're, say, you know, maybe in California, which I had this happen a couple of years ago, a young man got killed in California when they wanted to bring him back to North Carolina. We coordinated with a firm out there, you know, that did the pickup, did the embalming and the shipping, and they flew him into Greenville, Spartanburg up there in Asheville, but in this area it would come to Charlotte, and then we would take over from there. So no, there's really no limitation. I've gotten deceased that have come in from overseas. So what that expense normally looks like, it would depend on if it's a situation where another funeral home is involved, it would be whatever their expense is to ship them, plus the expense of the funeral home you're dealing with locally. So normally, if you're dealing with a local funeral home, they'll have a fee called receiving of remains, and then with whatever you picked out as far as the service is concerned. Now, if it's something where we can drive to go get it, then usually it's a mileage that's calculated depending on how far it is outside of our service radius.
So if it's in Georgia, if they're visiting children or something happens, you have to fly the body back?
Depends on what part of Georgia. If it's, and I'd usually look at the cost difference, because sometimes it's actually cheaper to fly them than to drive them back. So I normally sit down and do the mileage and evaluate what's going to be more cost effective for the family. Because there's been a situation, say, well, you know, mama's in Georgia and, you know, we want to, drive her home. You know, we wanted to be driven home, and I say, well, wait a minute, let's look at the cost. And I say, well, family, is actually a little bit cheaper if you fly her versus drive her, because when driving, you have to calculate that mileage. And so it just depends on the distance.
Can you just go make the car and bring it home yourself?
Actually, and you might think this is funny, actually you can. Actually you can. All you have to do, wherever that person passed away, you have to go to the registrar at the Vital Records and obtain what's called a burial transit permit. As long as you get a burial transit permit, you can throw Uncle Bo in the back seat and ride him on to North Carolina. Technically. Because one of my colleagues told me a situation where I think it was their dad or mom or somebody, and they wanted to transport them themselves in a U-Haul. So they went and got the burial transit permit, threw them in the back of the U-Haul, and took them wherever they were going. So technically you can do that. Technically you can. You had a question.
Yes, you said the pre-need to at-need,
Mm-hmm.
that once you get your money on the insurance company,
Mm-hmm.
that the remaining balance goes to the clerk of court, to the estate.
So pre-need to at-need, so whatever's remaining from the funeral bill, from the insurance itself, it will go to your beneficiary. If it's over $1,000 as far as this left in the pre-need fund itself, that goes to the clerk of court. See what I'm saying? So if you had a pre-need trust account, hypothetically speaking, that had $15,000 in it, and the funeral bill came up to 10, so there's $5,000 left. That $5,000, that has to go to the clerk of court. But with insurance, if an assignment is in place, you don't have to worry about that because it's going to your named beneficiary. See what I'm saying? Clerk of court has to put it in the estate, and then they handle it from there. That's something you don't want.
So it's best to
It's best.
underestimate or underestimate the cost.
It's best to use insurance.
Oh, okay.
So that way when you have an assignment in place, whatever's left over goes to your named beneficiary. So you don't have extra money sitting out there that has to go to the clerk of court. See what I'm saying?
So this pre-need and at-need is just what you do when you don't have insurance.
So pre-need to at-need, that's basically when a pre-need, when that person passes away and it becomes at-need. So at-need means at the time of death, pre-need meaning before death. Okay, did I answer that question? Right, any other questions? That question. Okay, I'll give you a good example. I had a family last year in Asheville. There was a young man in their family that passed away. And they said, well, Mr. McCain, all we want to do is put him in a pine box and have a direct burial. So they didn't want any viewing, no funeral, none of that. They just wanted to put him in a pine box and take him to the cemetery. So in a situation like that, he didn't have to be embalmed because he wasn't viewed. So we normally recommend embalming. Now, you know, us peoples typically, you know, what's the day? Saturday. You know, somebody died today, the funeral going to be next Saturday. So, because you know we got to wait on Pookie and Ray and Junebug and all of them to come from out of town, you know, to attend. So in a situation like that, that's when embalming is recommended. That's when embalming is recommended. But if it's a situation where it's a very short turnaround, there's not going to be either a public viewing or not an extensive public viewing, embalming is normally not recommended. I had a situation where I had a family, you know, they just wanted a small private viewing, just the family. And, you know, we laid her out, you know, she wasn't embalmed, and it was just the family that came in and spent maybe an hour with her. Anytime you're looking at a long delay, and then you're going to have other people of the public come to view, you know, for health and sanitary purposes, that's why we recommend embalming in a case like that. Okay.
But do you still have pine boxes?
We do.
Do you really?
This went out too. We do.
I know they used to do some years ago.
We do. We do.
And you still do?
Yeah, I ordered one last year
Wow.
for that family I just mentioned. They wanted a pine box. I said, okay, well, we'll get you a pine box. So yeah, they're still made.
Wow.
Question.
Question. Put it this way, if you have some unexplained events that take place, say like with COVID, which, you know, there was a lot of deaths, so it extended the funeral. Would you still have to pay for the embalming when it was not in your hand, you know, because the funeral home was so backed up because of it?
So basically, if there's a long delay. So now during COVID, now that's when things changed a little bit. Now that's when funeral homes pretty much adopted their own policies as far as what they would do when it came to a COVID death. You know, some funeral homes, you know, I had some colleagues, you know, they would not do any embalming with COVID cases. They had to be cremated or direct burial. They wouldn't do any embalming. You know, I did embalming, you know, for COVID cases. And, you know, a lot of times there was a delay if other family members had COVID and you had to delay the services out. So the only thing that you would pay for at that time, you know, what I was doing, you know, in a situation like that, you know, the only thing they would have to pay for was just the embalming, and that's it. Some funeral homes would charge storage fees, but, you know I personally didn't do that because of the situation. You know, this is something that we had never encountered before. But some funeral homes during that time, they did do embalming, some didn't. So it was just left up to the funeral home. Did I answer your question?
So I was asking,
Yeah.
the events that are out of your control.
Yeah.
If you didn't want to be involved, but you have no other choice, like you say, because it's extended.
Right.
Would you still be responsible?
Just for paying for the embalming.
Okay.
Yeah. Any other questions? Any other questions or concerns? Question.
I'm gonna say one thing real quick. I looked stuff up. I see guaranteed whole life 265, where at 65 it's paid up, you don't have to pay any more premium. I don't see what you're talking about. So that's why I'm gonna talk to you later, or anybody that has that problem, because it just don't sit well with me that you
Right.
do that.
Right. Yeah. I haven't heard of that situation either.
Oh, it could be.
I know they do us different.
Yeah.
Oh, it could be a whole life policy till you get to 65 and then it turns to something else.
Right. But the only
Set
situation,
up there. That's
yeah, that's a weird setup.
set it up. I ain't saying they set you up.
Set up.
The one thing I do want to emphasize, like I said earlier, you know, with your insurance, like what Mr. Dixon said, make sure you have an accidental death rider on there. Because I did have a situation some years back where a lady's husband passed away. He accidentally scalded himself and caught an infection, got sepsis, and passed away. Okay? And so we submitted the claim to the insurance company, you know, initially. And, you know, they had to wait on, you know, the death certificate to be processed, because back in that time, you know, now death certificates, we can get them much quicker because they're electronic. But back in the paper days, you know, we had to wait some time. So when we got that death certificate back, and I looked under the section that said manner of death, and the doctor ruled it an accident. They did not pay that claim. They chucked that thing out so quick, and she ended up having to come out of pocket and pay it, because she did not have an accidental death rider on that policy, and the doctor ruled it as an accident. Even if we didn't think it was an accident, whatever that death certificate says, that's what the insurance company will look at.
But most of
Out of pocket, did the insurance pay her, or it just won't pay anything?
Nope, wouldn't pay anything.
now,
So she
Wouldn't
just
pay
paid
anything.
that money for
No.
In that situation.
That's the same thing that if you say that you don't smoke and you do some kind of tobacco. I saw a lady that actually, she said it was her anniversary from not smoking for like 7 years. Took a picture on Facebook.
Woo, yep.
And they wouldn't pay, but they said that cigarette in her hand means she could still be a smoker.
Yep.
And her family said no, she was just having it because she's like, I haven't smoked, it's been 7 years. But you know, they're looking for a reason, so don't give them more.
And I'm glad you said that. I'm going to throw this out here too, just for people's, for informational purposes. Now, we're giving this information so you ain't got to go this particular route, but as we know, GoFundMe is the popular thing to do now when people are having some challenges paying for funeral expenses. But I want you to be aware of that. Simply because I have had 2 occasions now. At my funeral home, I do not accept GoFundMes. I have a different fund that I use called Fund the Funeral. It's something that I set up to where when patrons make donations, they get a receipt, they see that it's going directly to the funeral home, to that person's expenses. With GoFundMe, I have had 2 occasions where families, didn't have the means, and they set up GoFundMes, and people donated, and they raised the money. Family took the money, and we never saw a dime of it. Never saw a dime. So be careful with that. Now with GoFundMes, when you're making a donation, it goes to whomever set it up. So keep that in mind. Now that's why I had to switch it up and use a fund to where when people make donations, they know it's going to the funeral home for that purpose. So please be careful of that, because we have a lot of GoFundMes out. I saw your hand and I get your hand. Okay. And you correct me if I'm wrong. A lot of times, if you have a knowledge of what the name of the company was that they used, you have no earthly idea, and that's going to be the challenge. Most of the time, if they had some type of draft coming out in their account, you can see a company's name there, and you may have a reference number of some sort. That's usually a good place to start. And then look up the company, and they'll do a birthday, social security search to see if they had policies. If they had it on a draft. Now, if it was a situation where they were paying the insurance man every month, that's going to get a little complicated if you don't know the name of the company. But if you know the name of the company, that's a good place to start to search for policies that you may not know that person has. And then if it's a situation where, and I've seen this 100,000 times, they took it out with a company back in 1965 and then it changed names 10 times since then, you can always call the Department of Insurance to get the up-to-date company name and contract information.
What about if you have more than one child? You have one child that's power of attorney, and one child that's a living will, and then another child that's on the beneficiary of the insurance. Only that one child is on the beneficiary of the insurance.
Very good question. Very good question. I'm going to let you finish with that.
I was just going to say, and when it comes to that, one child, where do you fall in there?
Very good question. Now, this is the statute for the state of North Carolina when it comes to doing arrangements. Now, if it's a situation where you got multiple children and have those things, what we look at as funeral service practitioners that trumps everything is in the health care power of attorney. In that health care power of attorney, there is a directive, as Mr. Webb had discussed earlier, that discusses the mode of disposition. Whoever that health care power of attorney is, has to say so. Durable power of attorney dies when the person dies. So if you got durable power of attorney, I hear people coming all the time and say, well, I got power of attorney, I got power of attorney. Do you have health care power of attorney? Because health care power of attorney is the only one that carries over after death because it designates the mode of disposition. When I say disposition, whether it's burial, cremation, or something else. But regular durable power of attorney, when that person dies, it dies with it. So even if, and I've had a situation where a family came in, now this sister was beneficiary on the policy. So beneficiary feels like, well, I got to say something, I got the money. Technically, no, because the other sister had health care power of attorney. So the beneficiary doesn't trump the health care power of attorney in a situation like that.
Even on the insurance?
Don't matter. It don't matter. That health care POA trumps everything. And when it comes to making those arrangements, so if the person with the insurance had $50,000 on mama, she feel like, well, I should be the one to make decisions. I got the money. But sister girl over here got healthcare POA, or sister girl over here with healthcare POA, Trump's the one with $50,000 policy. So it's always good to make sure those things are consistent. Because I have had a situation where a family came to a stalemate, and I had to leave the person out for about 2 weeks because they couldn't come to an agreement. Because one said, well, if we ain't going to do it this way, I ain't paying for that. And the other one here said, well, I got a healthcare POA, so this is what I say. And if you're going to be healthcare POA, you want to make sure you have some fun. This person had a healthcare POA, they had no money. But she was still in charge. Yeah. Oh, these are real life stories, folks. I can't make this up.
So you ought to have the one that's in charge ought to be on the benefit here too.
Sometimes it should be, but a lot of times it's not. It should be. That's what I say. It should be consistent, but a lot of times mama said, well, I'm going to leave the money to this one, but I want this one to take care of my health care. And then when mama died, and then when mama died, yeah, exactly. So you want it to be consistent.
Pass that on to the children. If you didn't have any say so for them or
You can't change it. But what I have done in situation, I haven't had a situation like that last year. You can't change it because that's in place. But I had the person say, well, I really don't want to have anything to do with it. I made them sign a disclosure stating, and I had a note around it, stating that you waive your right to this. So that way they can't come back 2 weeks later. Man, I put mama in a purple casket, I want the red one, so I'm going to sue. No, you waived your right. And you signed, and a document was notarized for that, stating that you waived your right. And really, what I do in situations like that, the state has a statute called a 10-day hold. So if it's a situation where I believe the family is going to have some difficulties, I say, okay, you know what we're going to do? We're going to wait 10 days. Because after 10 days, the right to disposition has been waived. So third cousin Sue can come in at that point and make arrangements if she wants to. After 10 days. Did that answer your question? Any other questions?
All right, what about suicide?
Suicide!
Suicide!
Oh boy!
Lester, your wheel, Lester.
That's another one. That's another one. And I believe Brother Evan would agree with me. You better make sure you read your declaration page in your insurance policy. Most have a suicide clause. So if on that death certificate, that doctor checks on the manner of death, suicide, you ain't gonna pay. And then, so that's why we need to make sure everybody is in good mental health, so we won't be going and offering ourselves or other people offering themselves so that, we don't run into it.
Is there such thing as accidental suicide?
Accidental suicide? Well, there was a situation I had last year. I got a scenario about every question. I had a situation last year. Yeah. See, I had a situation last year where a guy accidentally fired a gun and he hit himself in the head. So they had to investigate whether it was self-inflicted or whether it was accidental. So they did rule in that case that it was accidental, and she had an accidental death rider, so she was covered. But if in the event they had ruled it suicide and that's what's on the death certificate, then it wouldn't have paid out. Okay? Any other questions or concerns? You got one, Ms. Cantor?
I got a problem. One of my boys is on it, and could the rest of them step in and get their life?
You said so you have a policy of one of your boys.
My youngest boy is on my phone.
Mm-hmm.
And my oldest here, the rest of them step in and get some of the money if I have one of these.
Yeah, whoever your beneficiary is on that policy, that's who gets it.
Well,
So it would be left up to them if they want to distribute it out to the other children, but whoever your beneficiary is, that's who's going to go. So they can't come in and take it. It's just, if that person is generous enough to say, well, I'm gonna give everybody X amount of dollars, that's what's up to them. Okay? Yeah.
When you were saying about the accident death rider, does it have to be through that same company that you have the insurance with?
That's normally when a policy is written, that's when it has to go to that specific policy that's being written out. So whatever company you have, you should ask about this. If they have an accident death rider, and they'll just tag it on there. It's normally like maybe $1 or $2.
Really?
Mhm.
So, can you have like a life insurance policy, Gerber Life, and then an accidental insurance policy for your bank?
Yeah. Now, if you just have a straight accidental death policy and that person died from an accident, you would want to use that in that case.
Okay.
See what I'm saying? So what we were saying is if you're taking out insurance or anything, and you don't have a separate accidental death policy, you want to make sure that the accidental death benefit is added on as a rider. So basically it's like a little policy within the big policy. If that makes sense.
All right, thank you.
You got a question? Okay. Okay, appreciate it. Who had, someone else have one? So if it doesn't good, I'll ask for the evidence, so she asked, like, if somebody died in an accident, and didn't pay out, sometimes it would return free.
It has to have a certain curriculum. Return policy, return premium is literally next to the name of the account. Return premium. It doesn't have it on the account. I'm just now seeing it anymore.
It just goes away. Yeah. Any other questions? Any other questions? Okay, well, we get ready to eat.